And thanks for joining us, everybody. Good afternoon. I'm Josh Diggs, Director of Claims at Orion Risk Management. And today joining us is my partner, Zach Brown, also at Orion Risk Management, and attorney and founder of Soleiman Law Group, Matt Soleimanpour. So thanks for joining us today.
Thank you, Josh. So we're here, obviously, to discuss weed. A lot of people's favorite
To be blunt.
That's right, to be blunt.
Thank you.
So we're in the weeds right now.
Good.
So, as you know, California passed Prop 64, and that means weed is legal. So people can smoke weed legally. However, we're here to talk about how that's going to impact the workplace and how the use of marijuana might have some spillover into accomplishing certain things in the office, in the factory, out in the field, whatever particular walk of life and industry that you're in, it's going to have a little bit of an impact. So to let you know a little bit about myself, I'm a labor and employment attorney based out of San Diego. We practice throughout Texas. And this is essentially what we do. We talk to employers, we consult with them on what they can and can't do. And one of the major factors right now, and obviously it's pretty prevalent throughout the country, is this issue of marijuana in the workplace. So California typically is a little bit ahead of the game, but you'd be surprised to know that there actually are some other states that have kind of moved forward in the recent developments of what is permissible in the workplace, what is not permissible. So we're going to touch on some of those subjects. We're obviously going to give you some advice on best practices, and then we'll take some questions. We'll review, where we think the law is going to go. And obviously, if there's any inquiries in between or thereafter, I'm happy to field any of those as we proceed.
Perfect. So Matt, and before we jump in, I'm just gonna drop some knowledge, some stats that we looked up, just to kind of give the general landscape, if you will, what some of these employers are facing, right? So you mentioned California. There's 158 million people worldwide that have used marijuana. These are a couple of stats of it. So production is up 10%. Tenfold in the last 20 years in the United States, right? 11 states now recognize weed, marijuana for recreational use, and 15 have decriminalized marijuana, right? So it's a $1 billion industry, and also to go along with that is now it's much more socially acceptable than it was 5, 10, 20 years ago, right? So the challenge now is, how do employers navigate all of this with the understanding that that their employees can in fact recreationally use this, and now they've got to manage sort of the day-to-day operations and without hindering their business, without changing their culture, and doing their best to avoid any landmines in either the workers' comp realm for lawsuits, accidents, but also any employment law issues that might relate for any terminations once we find out that someone is using marijuana. So
that's right. This is going to get pretty conversational. So let's say we dig right in, and then see what you got prepared for us, and then we'll branch off on all of that.
Absolutely. So we're going to just kind of run through a few things, and then I think the best way to do it is, everybody has their own creative solutions to things. They also have some inquiries that they're facing, industry-specific things. So we'll touch on that. But let's just kind of hit the main details first and get this rolling. So obviously, this is us here. We got
the good-looking panel there.
We got Zach. You got myself. And I wish the nose was a little smaller in my photo, but hey, it is what it is. All righty. So I'm going to start us off here with a little clip just to lighten the mood. Let us know if you have any issues with volume, but it should be all functional.
Uh-oh, Mac attack.
Hey, there he is.
Hey, I need that Mendelssohn file by 4 o'clock.
Okay.
And this is not your bro, this is your boss talking.
I'll give by 3:30. How's that? Okay.
Matt!
What?
We hold on.
Woo! Okay.
Jesus, so far. Hey, we gotta go work on that thing we were discussing.
What's going on?
We have to go work on that joint file.
Of course,
Yeah,
joint file. You guys are doing a joint file? We have a joint file.
Yeah, we're pretty deep into it. It's tight. It's
a big file.
pretty thick.
Pretty fat file.
It's dank.
We should blaze through it, probably.
Yeah, we got to file that for the THC Corporation.
Okay.
Because we are in the weeds.
Okay, so the reason why we showed you that is obviously marijuana is a little bit more, as Josh said, a little bit more prevalent as far as recreational use. There obviously is medicinal use for it, but now that it's legal to use recreationally, people are smoking weed. I mean, I think people kind of always smoke weed, but now it's more readily available. The stats show, you see here in this figure, it was 7% 2013, about doubled to 13% 2016. Then we get up to 15% in California that use, and then 47% that tried it. I think we could probably double most of those numbers now, to be honest with you. I think you'd be remiss to bump into somebody who either hasn't smoked weed or is already high within the last few weeks. I'm sure you at least talked to somebody. So obviously, no judgment as to anybody who smokes weed. I went to college certainly, so I've dabbled, but at the same time, how is this going to impact the workplace? You probably don't want to work with somebody who's just finished blazing a joint. They're probably not going to be as sharp as they normally would be on a Tuesday morning around 9 a.m. So what can we do about this? All right, as you know, weed is legal, but employers, at least in California, at this time, they still have the power to set forth their various policies and procedures as they see fit. So even though it is no longer considered an illicit substance in California, it is obviously still a scheduled substance federally. You can still limit that. You can still limit it. You're entitled to do that. It's much like how employers can limit smoking cigarettes on the workplace. Drinking alcohol, for instance. It's very much the same. It's still a substance that impacts performance, that impacts attention, that impacts safety. So you're entitled to set those particular policies and procedures as you see fit, as long as they're set up properly. So our first tip here is just go ahead and review your current drug testing policy and California law, all right? Now, you're gonna wanna take a look at your pre-existing alcohol and substance abuse related policies just to make sure they're very clear and they're set forth in there. However, let's take a look at the drug testing policy. Okay, how are we going to determine whether somebody is a user or a potential user, and how is that potentially legal as far as the type of testing that you're doing and when? So let's pull that up first and take a review, all right? And then we're gonna give you some tips on how we can kind of dive into that. So number one, when we're talking about drug testing, now we're talking about whatever kind of testing you're doing. You can either do urinalysis, there's other types of tests, there's saliva tests. I've seen employers do all kinds of wild things, but long story short, you have an entitlement to one pre-employment suspicionless test, okay? So what that means is that you don't have to have any reasonable suspicion to test somebody for the use of marijuana, as we're talking about today. Now, there could be other drugs we're testing for, but certainly marijuana. You don't have to have any suspicion. Before they start work, before they're an actual employee on the rolls, you can do a marijuana screening test, okay? So if you're in an industry, for instance, that uses heavy machinery, or people are out working in factories, there's safety factors, or if even you're not doing that, if you have transportation involved in your particular line of work, you're transporting materials, either be it an 18-wheeler or just buy a simple car, maybe you're in a catering business or something like that.
Or food, even.
Right.
If you make food.
Correct.
Or manufacture food.
Anything like that. Yeah, if you're in the car, you're going to be in situations to where you probably want to be sharp and coherent. This is something you're going to want to do. You want to put that into your policies. At least give yourself the option to conduct a drug test, and you're going to want to put that in your pre-employment paperwork. Make sure it's very clear. You don't want to just give somebody a handbook and it's kind of buried in there. Have a freestanding sheet of paper that explains that The employer has a right to conduct the test, and how it's to be conducted, and make sure you get them to sign off on that. This is really your one silver bullet, the bullet in the chamber that you're going to have to conduct the test without any other type of factors that come into play. So I would encourage all employers to draft a freestanding pre-employment screening test and acknowledgement. It can be as simple as just a few sentences. Have them sign off, and then it's up to the employer whether they want to spend the money to actually conduct the testing. I think you kind of want to take that on a case-by-case basis.
Is that something that your firm does? If somebody wanted that freestanding form, do you have a template that you could provide?
Of course, and I'd be happy to provide that to anybody that would want to take a look at it. And then if anybody wants to consult on the issue as to how you go about employing that or putting it into force, we can do that as well. And we also can forward employers to our recommended drug screening labs, because what we'll talk about a little bit later throughout this presentation is the quality of the testing is also a major factor too. You don't want to just throw money away, get a nothing test that has a very low factor of turning up any type of results. If you're going to do it, you should do it right, and we can point you in the right direction. All right. So pre-employment, suspicionless test. That's your first opportunity, and in some situations, that's really your only opportunity to conduct a direct screening test.
So on that note, then Matt, let's assume that they have a pre-employment suspicionless test and it comes back positive. What steps does the potential employer need to finalize at that point as a condition of simply not hiring that person? What procedural steps do they need to do to ensure that they are covered properly and that they're not going to essentially bring this person on?
It's a great question. Luckily, the procedure is pretty simple. I mean, you can just notify the applicant that they're being denied because they had a positive test. It's up to the employer whether they want to provide some type of appeal process, but it's not really necessary because technically the person who's being tested here, the applicant, is not an actual employee yet. Now,
it's not a protected class or anything, so they can't sue you for discrimination or anything
correct.
like that, right?
Correct. At this time. Now we'll get to where I think the law is going a little bit later. But right now,
drug users are going to be a protected class?
Well, not particularly drug users, but where I see it going in the future is that I see individuals who have the actual medicinal marijuana card, the actual card. I don't think it'll be recreational drug users, but there still are people in California that have a medicinal marijuana card. Anybody who's been to a dispensary, I'll admit I've been to one, and if there's one line for people that have a card, and there's another line for people that do, and people that do have the card,
much longer.
They go straight to the front. They can get what they need immediately, whereas just the regular consumer has to wait. So there still are people that have prescriptions, even though it's recreational, to obtain marijuana in whatever form.
So sorry, another side question. If somebody does test positive during that suspicionless test, and then they show the employer, hey, I have a prescription for this.
Right.
Can that still be a reason for not hiring them?
At this time, yes. At this time, yes. Employers are still entitled to have rules that identify that they don't need to tolerate use of these types of substances. At the suspicionless test period, before the applicant's an actual employee, you can legally deny the application without any right of appeal or anything at that stage.
Can you do the same thing for other things like opioids?
Yes.
If somebody's on OxyContin, or if that's even an opioid, if somebody's on OxyContin, could you say, hey, we're not hiring you because of the prescription drugs that you take?
Well, that's a little different because they may have some type of disability to where they have a prescription, so that you would want, but you can conduct testing for them. So my answer
I didn't mean to get too far.
Well, typically on that drug test that's clearly spelled out, it would typically be illicit drugs, right?
Correct. Yeah. Okay. You're usually going to write like illegal narcotics and things like that.
So what would be illicit drugs, as an example?
Just like marijuana, cocaine, methamphetamines.
Right. So marijuana. Not so much. So in the initial pre-screening or the initial pre-employment test, they're typically not going to test for prescription type drugs. typically, right?
Correct. I think that scenario probably comes up more where that you already have an active employee, and perhaps there was an incident or there was a situation that led to the testing during their employment. And then you can kind of get into that interactive process as to whether they have a prescription and whether they don't and how that might impact their job, and so on and so forth. But as it relates to marijuana at this time, you have that opportunity to deny employment if they test positive at that early stage.
Yep.
Okay, so
with no additional steps after that. No
Correct.
explanation, no appeal, no nothing. You're
Exactly.
within the law.
yes, you can just deny, and that's it.
Okay.
And you're good. Now, of course, in the future, I think that might change a little bit, but as it stands right now, that's the law, and you're within your rights to do that. So then there's another stage as to when you conduct this type of drug testing for marijuana. That would be based on what we have here, a reasonable suspicion. So number one, we have pre-employment suspicion list. That's not even a word. That's just something I kind of made up. Suspicion list test. And then you have reasonable suspicion tests that can be conducted during the course of employment. And we just listed an example here. Obviously, one of them would be they get into a major accident. Maybe they get into a car accident, or they have some type of accident causing injury to
Workplace injury.
Right, workplace injury either to themselves or others, or maybe you have some type of major property damage, something that would suggest, maybe this person wasn't entirely coherent, or it's just best practices as an employer to look into it.
Okay. So sorry to keep butting in, but
Okay.
as an employer, what if I smell it on somebody, or what if they come in, their eyes are bloodshot, or sleeping at their desk? Like, is that good enough reason without me getting in trouble that I need to know if this person is coming into work intoxicated or not intoxicated? Under the influence of some sort of substance.
Yes, so that's actually correct. So that would fall under what would be deemed a reasonable suspicion. But with those types of things where it
somebody
involves,
else involved as
right,
well,
when you're talking about subjective issues,
Yeah.
you want to make sure you document it, conduct some type of investigation. So it's not perceived that this person was being
Taken on,
singled
yeah.
out.
Yeah.
Correct. So you're going to want to make sure that you have some type of data backed up. Like you said, talk to a witness or witnesses, gather some type of information.
Hey, can you go talk to this person to see if you also think?
Correct. Because there have been scenarios and cases in the past where individuals, ended up suing the employer because they felt there wasn't it was maybe like a race-based issue or something like that.
They wanted to get them out, so hey, I'm suspicious every day.
Right. Exactly. So when we're talking about subjective factors like appearance or smell, then you're going to want to make sure you document that before you submit somebody to a test. But certainly,
it still falls under reasonable.
It would be a reasonable suspicion, but again, the key word is reasonable. So you're going to want to make sure that that you are reasonably reviewing what those suspicions are and accounting for it and documenting it and making sure that you're protecting yourself as an employer from a potential retaliation lawsuit.
Yeah, I think the accidents are kind of the obvious situation, but just kind of disruption of the scent at work, or maybe just lack of production.
Yeah,
whatever.
Lack of production, body language,
slurring. I mean, if
you have clients that come in, that can be offensive to
appearance.
Yeah. So the key is just to be able to justify that reasonable suspicion.
Right, because when you're submitting somebody to take a drug test, that's a big deal. So you're going to want to make sure that you have your ducks in a row and everything's kind of lined up.
Yeah, that's a good point. Because as employers, we don't really see it as big deal. We do it so often with new hires and accidents, and with the regular employee doesn't see all that stuff. They're not involved in the hiring process or involved in
they don't
insurance claims. Just the regular employee gets a drug test. They're probably in shock.
So you go ask somebody who's sitting at their desk that they got to go pee in a cup. That's a big deal. So you're going to want to they're going to not take that one. Yeah. So you're going to want to make sure that you have your evidence lined up before you go ahead and do that.
Good point.
All right. So that's kind of number one and number two as to when you can conduct a drug test. And again, I want every employer to at least have some type of documentation in their handbook, or again, a freestanding form, which is recommended, to at least give yourself the option to conduct drug testing. I'm not telling you you need to do all this. I don't want you to go home and then revamp your policies, procedures, and the way you're hiring people and start having everybody, go to labs. Just give yourself the opportunity to do it. So that way you don't need to go back later or think about how you might regret what took place. All right. So a little tidbit. Random or routine testing is illegal in California. So you can't just this is not the NFL.
I was going to say, the NFL does it all the time. What are you talking about?
So you can't just randomly routine. You're not going to send your employees letters saying you've been selected for, random you'll get sued. So you can't do that here.
Does the NFL do it to California teams?
Collectively bargained though, right?
Yeah, so they're kind of outside the realm. There's waivers and essentially the integrity of the
Collective bargaining agreement.
Correct. Yeah. So, but if you're just a regular
ABC
California employer
construction.
like myself, like you guys, like most individuals who are probably watching us right now, you can't do it. You can't have routine or random testing. It's not allowed.
That's
So
crazy.
So I think
I didn't know that.
the one exception that most people would probably think exists would
Exception.
be, there you go.
Safety sensitive jobs.
Yeah.
So let's say you operate heavy machinery, or you work in, like I said, you work in a factory, a lot of, dangerous objects. You work in transportation.
Yeah.
Then you can do it. Then it is allowed.
So if you work at a credit union, you can't do it.
Right. If you work here,
if you drive a semi truck, that's
right. Or you're operating an excavator all day, or you're working in a factory that has all kinds of automated machines that can really hurt people, potentially kill people. Then you can do random testing.
What if they're in the gray area? Can they check in with you, or do they call maybe the whatever department polices this? As far as drug testing with the state of California, how do they know? What if they do very light manufacture? They manufacture pillows.
Mm-hmm.
Not really too much safety concern there, but we do have some equipment.
Right. So then you'll kind of evaluate that. You'll do a case-by-case basis review. Okay. You'll contact somebody like myself. We'll talk you through it. Best way to do it, though, is to have very clear job descriptions for your different types of employees that you have. So if you have, a job description that identifies all the essential functions of the job, and 1, 2, 3 of them involve issues that could be deemed safety sensitive, then you would kind of help yourself there. You'd have a little safety net for if you do elect to do random or routine testing.
And that's something you want to have in the pre-employment interview or whatnot.
So to fall within an exception like this, you're going to want to make sure your job descriptions are spelled out. They're given to the employee, prior to starting. If it's too late, draft it up and issue it to them at that point, because that's going to really be the only way that you're going to get yourself within that exception.
Okay. Rule. Another employer question. Yeah. Does it truly have to be random? Or could I just say, hey, I'm going to drug test John Smith and say that it's just random?
Right. So that's again how you start towing the line in potential lawsuits and picking on people, for instance. So there has to be some type of pattern or practice in place already. However you do it, but it can't be like discretionary up to like a particular HR employee or president of the company or whatever. Like, I'm going to drug test that person, because then again, you're potentially looking at a lawsuit either for maybe the individuals in a protected class.
Gets 3 in a row.
Right. Well, I mean, I get stopped by TSA almost every time, but it's probably the last name. But the point is that you want to develop some type of consistency if you're going to be doing random or routine testing, just to avoid those pitfalls.
Well, and so like anything that you do in this process, be able to document and clearly spell out why.
Correct.
Right. So, and that's going to be consistent for pretty much everything you talk about today. Is in all the protocols and procedures and processes you have, it needs to be clearly spelled out why you did it, and then be able to substantiate it, because if a lawsuit does come, you can very clearly spell out, this is why I did it, and this is our protocols, and here is proof that we did it the way that we said we were going to do.
100%. So every employment defense attorney's best friend is documentation. Whenever we come on site, and usually by the time I get to your office, it's not a good thing. So people aren't usually happy to see me. Mm-hmm. But the first questions that we ask are, let's see all the documentation, let's see the personnel file, let's see your policies and procedures. And if we have, like you said, job description setting forth the safety sensitive aspects of the job, for instance, or we have a policy that sets forth how the drug testing is to take place, and how our random or routine testing would fall under that policy, then we have that to fall back on,
Right.
And we can rely on that in the defense. But if we don't have anything, then it makes my job eminently more difficult. It exposes the employer to liability, certainly, and then it just leaves it up to the employee and his or her attorney, if you get to that point, to open interpretation. And 100% of the time, their interpretation is going to be that it was discriminatory, illegal, or harassing, or all the above. So what you're going to want to do, obviously, like you said, Josh, let's have policies and procedures set forth for this kind of thing. So you have the direct testing policy, you have the job description, you have your workplace, no drug use, no alcohol use policy, and they're very clear and they're very spelled out as to how every little aspect can take place.
Our very first webinar was over that.
It was. So I've got a quick point, Matt, and it's almost going back a slide too, because with regard to the suspicion, reasonable suspicion. So workplace accident is going to be probably the biggest one on that list, right? And so one thing I was going to say, I get this from employers a lot, is I think him or her being under the influence, maybe not marijuana, but any sort of any drug may have caused it. If you felt, as the employer, if you feel that the reason for the injury was the intoxication, whether it be marijuana or any other substance, you need to address this right away. Because while the intoxication defense is a statutory defense in California, the reality is it's a very, very high threshold to prove, and you need the doctor, high threshold, you got that. And you need the doctor to address that almost immediately, because you need to flag it and say, Dr. So-and-so, this person was under the influence. We believe it'll be confirmed in the test, but we have reasons to believe that this person was under the influence based on the mechanism of injury and what happened. Give me your assessment very early on to help us determine whether or not that may have played a factor. Because if we don't get that documented early in the process, it's very tough for a doctor then 2 weeks later to say, well, it may have, it may not have, I don't know. The reality is you've got a small window there to get the doctor to issue that report, and you still have some work to do on top of that. But if we don't get that immediately, an employer telling a carrier and examiner a week or 2 weeks later, I think this person was high. We might have the toxicology report, but if we don't have the doctor's findings as soon as possible, then there's the likelihood is that we may not win at trial. We may not be in a position to properly defend it.
So would you recommend that no matter what, if there is any sort of incident, that drug test is mandatory? And I know it may be a little bit more expensive, but here's where my thinking was that, and I'm not a claims person, but actually being around you and the team while you guys are handling claims, is that I feel like there's always a point in a claim where the question comes up, no matter the intent of the employer, but are we allowed to get rid of this person, right? Are we allowed to terminate them or terminate our relationship, employer-employee relationship? And if you have a drug test every single time, maybe it only happens once, but they test positive. It wasn't the cause of the accident, but that is a fireable offense. So would you recommend, or one, can they? Two, should they? I guess is my question.
Right. Well, let me touch on a couple things, and then we'll maybe probably provide some clarity in your question. So what Josh is pointing out is absolutely true. And there's two issues that are extremely important. So I mentioned previously that, we as a firm have relationships with labs that we rely on. And what I would encourage every employer to do is develop a relationship with the drug testing lab. So you can rely on the scope of their exams and the expediency as to how they conduct them. You need to have a relationship with the actual lab because you're going to want them to take care of the logistics for you. You need to be familiar with the process. You don't want to put yourself in a situation to where you're kind of blindly trying to contact a lab to have this testing done because you don't usually do it or you haven't really done it before. Develop those relationships in advance. So you know that number one, they're reliable, and number two, you're familiar with the process, so it can be done quickly.
If you don't have a lab, feel free to reach out to Matt, and he can recommend.
Correct. Depending on any locale. So we do work throughout the state for employers throughout wherever you are. We know where you can send some people. Correct. So then the second major issue is, especially if we're talking about marijuana, as far as the timing of when the testing is being done. Marijuana stays in your system a little bit longer than most other substances. So the reason why getting the testing done quickly is because the doctor, via the lab, can interpret, potentially at least give you an opinion as to when it was used. Because a lot of times what you're going to get, if you don't expeditiously conduct the test, is the employee is going to either claim, well, I smoked weed, 2 days ago, or I smoked weed, the day after the incident or that night because I had anxiety and I was stressed out. And then if you don't get the test done within a good period of time, those excuses are kind of going to hold up, and then you're going to have a tough time actually, potentially, if you want, terminating the employee or disciplining the employee, because you're not going to be able to definitively prove that they had it in their system, they were under the influence at that time. So that's why it's important, number one, to have the lab relationships so you can get them in there efficiently. And number two, as Josh said, get it done quickly and have your processes already set up so you can get them into the lab before they can kind of use these other excuses as to, it wasn't that day, it was 2 days before or later, what have you.
Yeah. So, but would you recommend that it's standard on any incident that happens?
Yes, absolutely.
Should a drug test be mandatory if there's an incident?
100% in your drug testing policy. It should just have some bullet points identified that.
So better to have it and not need it than need it and not have it.
Yeah, it's
right?
the same. That's the NRA, line, having a gun and whatever. But it's true. I mean, because as an employer, you want to have these tools in the chamber at your disposal as opposed to trying to play catch up and then it becomes too late. Because again, as we said at the outset, asking somebody to piss in a cup is a huge deal. And unless you have it spelled out, you're going to have difficulty getting to that point.
Yeah. No, good point. Better to have it and not need it. And so to answer the part of your question as to whether or not across the board, if you've got it in your policies and procedures, then you're covered on that front. And then the employer can then make the determination if the secretary that tripped over a cord may not want to do it. If it's a construction worker out in the field carrying rebar that fell into a pit because it wasn't paying attention, then you might want to dial it in there. So
as an employer, you can discriminate like that?
So I think
depending on,
you can have it. So I would defer to you on that. But my thought process here is that as long as it's laid out that post-drug accidents, the employer has the discretion to request it.
Correct.
It sounds like you'd be covered on that front.
Yes.
Now, that's where the reasonable piece kind of comes into play too, right?
Yeah.
And so you
I was thinking
covered.
in California, you got to treat everybody the same no matter what.
It's true, but it would also depend on the nature of the accident and a whole number of other factors. And really, you give yourself the opportunity to be discretionary as an employer. But certainly, yes. I mean, you don't want to never use it. And like, let's say you have 4 motor vehicle accidents. You haven't done it once, then all of a sudden you have a Hispanic or African American male, for instance, and then that's the time you decide to use it. Then you could potentially run into some issues there.
Good point.
So that's what I'm saying. Just do it across the board.
Try to be consistent.
Yep.
But again, at least give yourself the option to be consistent.
That's probably a better word. Just consistent in your practices.
Right.
Yeah. And definitely
maybe the secretary falling over the cord isn't necessary in that situation. But,
right.
We're consistent with medical only stuff.
Of course. And these are all things we can help employers, depending on their various industries.
They got a quick question, they can call you.
Yeah, they can contact me. We'll kind of point you in the right direction as to what you want to add and subtract.
So Matt, on that front, I think that kind of the next logical sort of discussion point, I think, is the testing itself. You mentioned the importance of going to the lab that is certified, and you have very specific requirements for the labs that you prefer to send them to. Walk us through that, and then let's also dig into the second part of that. As the employer, you get the results, then we know this is kind of really where the almost all the exposures can arise. How they respond to that. Positive test, do you fire them off the bat? And I know your answer to that. And let's talk about what should happen, what you would like to see as an employer after you get the positive findings, the sit-down discussion about what happens after that. So why don't you start off by kind of discussing the testing itself in the clinics?
Sure. So the labs that we have relationships with, they're all certified labs. They have certain processes that we're comfortable with, and they have a little bit more advanced techniques beyond urinalysis. So you have a few options. You don't have to just do urinalysis, although that's the traditional method that a lot of employers prefer. It's less intrusive because you're not, you're not taking a hair out, you're not drawing blood or anything like that. So that's by and large is okay. You can also do some other type of saliva testing, but by and large, you're going to want to kind of stick to your analysis right now because it's not going to be perceived as discriminatory or any type of intrusive type of behavior. So that's what you're going to want to do is develop a relationship with these labs that we're comfortable with that take care of the chain of custody issues. They take care of all the forms for you. So you literally don't have to do anything beyond make the referral to the lab. They'll take care of everything else. They'll supply the materials to conduct the test. They'll take care of the logistics to get the employee to either come on site or they'll send somebody on site, depending on what you prefer. Now, obviously, if you want these labs to come on site, that's a little additional cost. And they'll lay it out for you. But the point is the labs that we use, they take care of everything. You don't have to do anything beyond make the referral. That's it. Then you get the results back, okay? So that's the next stage, because as we know, none of these tests are 100% accurate, okay? But they're definitely in the high 90s. But anytime something's not 100%, employees who potentially have a positive test are going to be looking to exploit that slight hair of uncertainty that's associated with the test. So what do you do with that? You should also have within your policy some type of level of appeal that allows the employee to have the perception of due process in case there is, some type of positive test. Now, what you can do is you can layer that. So in California, there's no hard and fast rule as to rights of appeal of urinalysis. There's no statutory guidelines. There's no case law that says you do this. Really, it's just they kind of take it case by case. So the employer can do the same thing too. Let's say you have a serious accident and you don't really provide a right of appeal, and it leads to an immediate termination. Maybe you layer it by the severity of the incident. That's how you do it. And it's really up to the employer whether they want to provide the right of appeal or not. Okay?
Give me an example of an appeal. So I test positive and I say that's BS. I haven't smoked weed. What's the process after that? Hey, I want to do it again.
Right. So then,
okay, we'll do it again, but it's at the cost of the employee, or
no. In that stage, if you have an appellate process that allows for an appeal, then you would have to incur the cost and allow them to do that. So again, there's no rule that says you have to provide a right of appeal. However, if you do, it's perceived as extra cautious and will be deemed as a reasonable test and a reasonable termination if you have that right of appeal. So that's the employer's discretion, whether they want to have that or not. That's something that, again, that we can work with employers on a case-by-case basis. You're not required to do it, but if you want to have that extra safety net, and you allow them to have, a second test or something like that, then you can do that. Now, it's not going to require them to go back in there and get tested again, because what happens is most of the labs that we work with, they'll have the sample already, so they'll just conduct a second test with the same sample. A lot of people who watch sports, they understand that nomenclature that they call it like the B sample, for instance.
They take enough for 3 samples.
Right, they take
really,
enough to where they can test the same, so you're not having them go back in.
Right.
Again, that's employer discretion because of the cost. But if you want to be extra safe in your assessments of whether you're going to terminate this person, you can provide a right of appeal within your paperwork.
You being the guy standing in front of the judge and the jury, would it help you if you had 2 tests? If they ended up getting to you as an attorney would like to see,
if
hey, he tested positive twice.
Yeah, if you're asking me, what would you do if I was in your shoes? I would have some layer of appeal. However, I understand, I also run a business, so I understand that there's costs associated with that. And again, there is no law in California that requires you to do the right of appeal. So that's kind of a judgment call for employers to review. I'll tell you I'll give you the best advice I can give you, but ultimately, I'm not going to tell you how to run your business. You guys know how to run your business better than I do, and I'm not going to tell you what to do. However, if you have that extra layer, it will be beneficial and will support termination decisions or disciplinary decisions, whatever actions you deem necessary by a positive test.
So let's dig into this a little bit more, because to me, this is probably the biggest takeaway that the majority of employers are going to have. You get the positive test, and then how do you handle it, right? So you sit down with the employee, and you say, you had this workplace injury. We've gotten your findings, and they're positive. Should an employer, before they even start to go down the termination process, give this person an opportunity to explain themselves? Because they might very well say, yep, I smoked weed right before I got to the job site. That was stupid of me. I shouldn't have done that. And then they might acknowledge there, you've already done the work for me. Now you understand we're separating employment here. But at the same time, they might say, yes, I tested positive, but it was 0.000. I don't know the measurements here, but let's say it was a minuscule amount. And they may have said, I smoked weed, yes, but that was a week ago at a party. I haven't done it since. And do those limits and do the story matter when you're sitting down with someone? And so walk me through that scenario.
Okay, so number one, and again, this actually takes us to our second tip, is clarify your existing drug testing policy. So you're going to want your drug testing policy to be extremely clear and bulletproof to the fact that you have the right of immediate termination regardless of any positive test. Doesn't matter, you can do it, at least in the policy, okay? And you're also going to want to spell out, like we said before, how you're going to go about testing, how potential appeals are handled, if at all, if you do random testing and you're in certain industries that allow it. Make sure that's all clear so you provide yourself the opportunity to immediately terminate. To answer your question, it's incumbent on the employer to conduct, similar to a workplace injury when you do an interactive process or when somebody has a disability looking for an accommodation. When you're doing either an exit interview, if you're making the decision to terminate, is to conduct an interactive process. You don't want to simply send them a letter saying, you tested positive for this, you've been terminated immediately. You want to handle it properly to where you are allowing them the opportunity to be heard and they're interactively being involved in the employment decision that's taking place. So when you get the test, you bring them in and you conduct essentially an interactive interview as to the data you have. This is your positive test. This is our policy that provides for termination, immediate termination. And then it's up to the employee to provide any type of information or data that they have. Then you can make your decision at that point.
Yeah, I like that idea though. You come in and you just, hey, you test positive. Like, what's up?
Yeah.
What's going on? And you'll get them to probably say more than they should.
Right.
Right. To seal up any defense if you need it. Right.
Right.
Again, one of those things.
And again,
not need it.
It's all about the perception of due process.
Yeah.
You want to provide a perception that you have due process in your termination decisions based on positive drug tests. So you got your tests, you got your policy, bring them in, allow them to address the issue, explain the policy to them, and then let them know that you'll be making an employment decision thereafter. Or if you've already made up your mind, you do it right there. But at least you create the perception of that due process.
So let me ask you this then, Matt. When you're defending an employment lawsuit from an employee that was terminated for drug use, what is the biggest hole, or what's the biggest challenge that you face because of something the employer did not do properly?
Sure.
In other words, when can they actually get some real exposure for the termination by the way it was handled or the testing of itself? So what is the biggest,
Most common mistake.
most common mistake? There you go.
Right. Well, it's pretty much what Zach touched on earlier. It's the consistency issue. So regardless of the positive test or when it was done or how it was handled, if you are not consistently enforcing the policy, either the testing policy or the level of discipline that's taken by a positive test, then you're exposing yourself to potential liability if, let's say, for instance, the person is in a protected class. More often than not, when you get these suits, it's because an individual was either a woman, a minority, had a disability, was pregnant or something. I'm probably not going to have a pregnant weed smoker. I would hope not. But the point is that this person will say, hey, they've had other people who smoke or have been caught or whatever, and I'm the only one, or I'm one of the few who was terminated.
Okay, so I have a real quick question. What if somebody wants to change their policy? Say, well, yeah, up to this point, anybody gets caught smoking weed, then we suspend them for a week, if that's even a level of discipline.
Yeah.
And then now, if you get caught smoking, you're terminated. Do they just have to let people know of the change and then be consistent from that point on?
Yes.
Okay.
Yeah. So this is basically, the slide we got right here. You clarify your policy. You're all going to, trust me, everyone on the call or watching us right now, you're going to want to change your policy at least a sentence or two, because you're going to want to make it extremely clear. You probably already have policies that have the word marijuana in it. That should be set off, because employees now, most people recreationally use marijuana, similar to how they use alcohol. They're going to think that that's not a big deal. You want a separate sentence that says, something like, despite California's recreational legal use of marijuana via Prop 64 or whatever, marijuana in the workplace by this employer is prohibited, in bold or something like that. Make it very clear so the employee applicant, they know that that's going to fall under that bin of prohibited activity. Then obviously, if we're doing drug testing stuff, make sure it's clear on how you go about doing the testing. Make sure it's clear on, you do a pre-employment screening, and then if you have the requisite level of exceptions that allow you to do random testing, make sure that's clear too. So it's not a complex job, but what you're going to want to do is essentially just add like 3 or 4 sentences on the subject matter that we just identified. Make it clear this involves marijuana, and it doesn't matter, it's legal. Make it clear that you are doing a pre-employment drug screening. Make it clear that anybody who is found to have a positive test will be disciplined up to and including termination. Make all those things clear so that when you want to rely on them later, you have that, you have those tools that you can use.
On a separate piece of paper.
Right. On preferably a separate sheet of paper that's acknowledged and dated. Okay. So what's the aftermath now? Let's get out. Let's do that up there. So we touched on this briefly when we talked at the outset, but a lot of states, have modified what can be deemed acceptable use of marijuana, and some of them have stated that if you have a prescription for marijuana to treat a disability, then it will be something that is allowed by the employer. That's problematic though, because obviously every single job we have has different essential functions. Some jobs I'm sure you can do if you have maybe smoked a tiny bit. Most of them you're not going to be able to do. So some of these states haven't really, I don't think, dealt with the repercussions of what this law is, what these new laws that they've passed are. In California, they've attempted to provide marijuana for medicinal use to fall under protection via treatment of a disability. However, those laws did not pass recently. But just practically speaking, judging by how other states have allowed such protections, and then just the nature of, you know, California being a progressive state, and these laws, these bills, already being introduced by the state assembly, it's likely inevitable to at least some degree that there is going to be a situation or a law that allows for medicinal use of marijuana to treat a disability, and the employer will have to accept that essentially as an accommodation that they're allowing. Similar to how, let's say, you have, you know, allowing an employee to sit if let's say they work in a factory, but one of them has a hip issue, and so they have a stool for that person. It's like an accommodation. You're basically allowing them to use marijuana as an accommodation to treat their disability. Now that's not on the books yet, but I think that's kind of where we're going. So that's something that you're going to want to look into. How do you combat that, though? You combat that by having very clear job descriptions, okay? If you have a clear job description, and within the bullet points of that job description where you are listing essential functions, it includes, you know, maybe speaking to customers, or some type of operating a vehicle, or operating some type of machinery, or you know, some type of transportation element, or some essential function to where it's very clear that if you're under the influence of marijuana, it's either going to be dangerous or, you know, unacceptable to the employer. Then that's kind of how you could get around that.
On that point, let's assume that someone needs it for a prescription for a disability, but they also meet some of the essential job functions that you mentioned, right? So could an employer then send this paperwork that they get from a doctor certifying that they can use marijuana? Can they send that job description to the doctor and say, based on what you're telling us and these job functions, would you kind of push it to the doctor to make the call that it's still okay to be under the influence and work in this with these essential job functions?
Right. So I think that's kind of more of that would be like a more workers' comp situation, right. I believe, because in workers' comp cases, that's when you're kind of sharing job duties with a physician to see if they'll opine on whether you know, they're fit for duty. Okay, basically. But if we're just talking about a regular situation, I would extend the job description to the doctor and allow the doctor to make that assessment. The employer still has the right to determine whether somebody is fit for duty or whether they need to accommodate that person with some type of modified duty. So you're not going to be able to summarily fire the person. Again, we're talking about hypotheticals right now. Sure. In the future. You know, these laws aren't on the books yet. They probably will be. And again, that's why we're here to talk about, you know, what to anticipate. A lot of you already know most of the stuff that we already went through. So this is kind of, you know, some new information. You'll be able to conduct an interactive process and essentially identify that, hey, look, we're, you know, again, we're talking about the future. We understand you have medical marijuana to treat your disability. However, these are the essential job functions. All we can do is offer you some type of modified position or a separate position that will allow you to perform that. It's like the same thing if you have an employee who's got an injury and they can't do the essential job function. So you offer them modified duty or some other type of separate position.
Especially if it puts anybody else at risk.
Correct.
So I think it's the last slide here. So I have one final question, and I'll shut up because I always extend this longer than it should be. But so my old man works for the railroad, and because marijuana is federally illegal, if he were to get caught with marijuana, but if he did, court marshals would come in and arrest him. Right. Because even though he's in Florida, but since California has made it legal and federally, which means nationally, it's illegal. Have you seen any like back and forth there of specific industries or anything that it's really affected, that it's kind of a stalemate because California says it's fine and, you know, the U.S. government says it's not?
Yeah, well, so presently, you know, employers in California, they can still not allow marijuana use. So you're still good in California. But like we said, these other states that are kind of going here, and I think we will too, companies that conduct interstate commerce, like federally, are just following federal guidelines. And unfortunately, those are going to be the same companies that potentially get sued if they have an employee who is predominantly in a state that allows it to treat disability. So the best advice to those employers is just to follow federal laws.
Even if you have locations in other states, right? Because I know
if the employee is engaging in interstate commerce, like if they're driving a truck, if they're just sitting answering a phone,
got it. Okay. Well, I get
not going anywhere, then you would go state by state.
We've had some dispensaries reach out to us, and we've had a lot of conversations with them. And one challenge that all marijuana dispensaries have is getting an actual bank account. Because if you go to Chase Bank or Wells Fargo, legally, federally, they cannot provide a business account for you because they operate
the
in
banks.
all the
The major banks won't touch them because
credit
technically
unions
the assets can be seized by the federal government.
Right. So local credit unions that only operate in the state of California have been their way around it.
And that's why dispensaries predominantly operate in a type of cash business, because they don't have a place they can put the money because it could just be taken.
But they have to get away from, sorry, we're getting off route here, but they have to get away from that, because even in the world of insurance companies don't want to necessarily insure a company that handles with a bunch of cash and they have, $100,000.
And then you don't know if they're gonna get raided, and they'll have to cease operations for a period of time, and so it's difficult to write lines of insurance.
Okay. All right, sorry. So that's my last question. I know.
No worries. I'll just pop to the next thing. Again, how reliable are the tests? Again, talking about what we discussed before, it's extremely important that you develop these relationships with labs that are reliable. There's a lot of labs out there that'll give you substandard results, and they're going to get you into trouble, because then you have potentially false positives. You have angry employees who are going to be disciplined for things that weren't related. They also have poor technology to the point where they won't be able to tell whether the person smoked weed 5 days ago or 5 hours ago. So the additional expense associated with using certified labs that we would prefer you to use, trust me, it'll be worth it in the long run. You don't want to half-ass these types of situations.
There's also different levels of tests too, right? So I mean, you can have a yes/no. You can have a okay, what they do, cocaine or weed? I don't know. It's just a yes. Or you can do a higher level test that breaks it down.
Correct. So what we traditionally do is we'll partner an employer with not just a lab, but then a physician to interpret the testing. And that's kind of what we recommend.
Okay.
All right. So that's essentially what I have for you. If there's any questions.
There are a couple of questions. We got a couple of folks that attended in person.
Justin, did you have any questions? I think you ran into a situation, right?
No. So I just have a question in general. Matt, you said that you recommend having a policy in place for pre-screening, whether or not you use it. Do you potentially run into issues if you pick and choose who you're testing? Shouldn't you either test everyone or no one?
Yeah, so that's what we kind of discussed before about how we want consistency. So when you're just kind of picking people at random, you do kind of run yourself into some trouble at that point. But at least our advice at the outset is get the policy in there, and then when you're ready to use it,
use it consistently. So like if the secretary came in, not to keep using that example, but if a secretary came in, maybe you don't drug test 8810 class code, right? But the 4736 truck driver, we do drug test because it's I forget what he called it, but a safety oriented position.
Safety
as
sensitive.
long as you stay consistent, right?
Yeah, so to answer your question, you're absolutely correct. You would run into some issues if you're kind of inconsistently employing the use of the testing process. But the advice, at the outset is, let's get the policy in there immediately. And then when you're ready to use it, when it looks like you have the infrastructure in place and you're kind of familiar with how the process is going to go, then you go ahead and use it. And then Zach's also correct too. Even though you might have a blanket policy, maybe you don't use it for a certain type of job applications. But at least initially, change your policies. It's really just a few sentences. Get them in there. So at least if you need to, at some point down the road, when you're ready, you have it. You have
Excellent.
Did that answer your question?
Yes, thank you.
Yeah.
So I'm going to do my best to summarize what I felt were the takeaways, and then I want you to jump on in with anything that I may have missed.
Sure.
But it sounds like, without a doubt, documentation has to be key throughout this entire process. You definitely want to have your employee handbook, your policies and procedures, particularly as it relates to drug testing and the appeal process, nailed down and as airtight as you can have them. So you would likely have an HR professional or an attorney review them to make sure that they're as strong as they can be.
Right.
You definitely want to develop a rapport with the drug testing labs so that you know what you're getting into, you know the process, and also you've got some back and forth rapport and communication or a channel for it.
Correct.
And if you feel that the injury or any injury may have resulted from that person being intoxicated or under the influence, you need to make sure that the doctor weighs in on this as soon as possible, or else you're going to have a tough time trying to win on that front. It's a tough threshold to prove. We just touched on this too. Be consistent with both how you administer the testing and also the response to any positive findings.
That's right.
And yeah, the appeal process can be particularly important. And you also mentioned considering layering it to the employer's benefit.
Correct.
Is there anything else that you felt that I missed out? Just key takeaways?
No, I think that's absolutely correct. You know, go back, look at your policies, make sure you're clear, you know, about marijuana not being acceptable use in the workplace. Just make it clear. Separate sentence, bolded. Just make sure it's out there. And then, like you said, drug testing, set forth the manner you're going to do it, why you're going to do it, and when you can potentially do it. And then the termination process that would result, I'm assuming, a positive test. And that's essentially it. I mean, it's really documentation.
So standalone form, you mentioned that.
Right.
Standalone form.
Right.
Develop relationship with testing lab. Consider an appeal process. I would say that helps your defense and just makes it more ironclad.
Yeah, no doubt.
And then be consistent.
Got it. And so the folks that are watching are going to be watching the recorded version. Matt, how can they get a hold of you?
So you can reach me by email, which is usually the best way to get me. It's just
Which
Matt,
is on slide number 2.
right, Matt@Soleimanlaw.com. Just go to slide 2. You have my info there. And you also welcome to contact these fine gentlemen here, and they'll refer you to me if there's some other method of communication you prefer. But email is always the best. We'll respond to you immediately. If it's either a lab referral or you want us to jump in, take a look at your policies and make sure that they're up to snuff. Whatever you guys might need, just let us know. Send us an email. We're happy to help you out.
Excellent.
Thanks.
Well, thanks everybody for joining us, and we would encourage you to reach out to. You can check our LinkedIn, social media, YouTube. What else are we on, Zach?
Everything, I think, except
Everything
for
you think.
Tumblr.
Everything except Tumblr. So thanks again for joining us, and see you soon.